definition of Memorandum of Association is provided under Section 2, Subclause 56. It contains the layout of a company in the form of 5 clauses. It can alter any 5 clauses of the memorandum as different conditions in addition to a special resolution. Earlier, my object was only to work in the district of MYSURU. Now I want to work in the entire Karnataka state. So then I have to have the change of object clause. Hearty welcome to my dear students for Company Law BCom second semester subject. I am Professor Rajesh Ella from Department of Commerce and Management, Vidhyaashram First Grade College, Temple of Excellence, MYSURU. This is the 4th session of our formation of a company. In this session, we are going to learn the major differences between Memorandum of Association and Articles of Association in case if the company wants to modify MOA and AOA, what are the clauses are there and what is the procedure we are going to learn in this session. In our previous session, we learned about the 2 important documents, Memorandum of Association as well as Articles of Association, and what are the contents were there in our memorandum as well as articles. In today's session, we are going to have the key differences of MOA as well as Articles of Association. The first most difference here will be definition and the meaning. The definition of Memorandum of Association is provided under Section 2, Subclause 56. It contains the layout of a company in the form of 5 clauses. Means the Memorandum of Association is a document which is framed with 5 clauses: name clause, capital clause, object clause, and next one, association clause, subscription clause. These are the clauses what we have. The definition of article says, provided under Section 2, subclause 5, it consists of the regulations and bylaws of the company. Means, what are the rules and regulations are there in our company and when it can be modified, if it is modified with the help of the bylaw. The second most difference what we have here, position and status of MOA and AOA. It is a supreme legislation, but it is a subordinate to the provisions of Companies Act. They're saying that for the Companies Act 2013, it is the subordinate to the provisions of the Companies Act 2013. But whereas AOA is the subordinate to the both MOA and the Companies Act. So AOA is subordinate for both Companies Act 2013's provision as well as MOA. But MOA is only the provisions for the subordinate to the provisions of Companies Act 2013. In the next third difference, registration and filing. It is mandatory to register MOA at the time of incorporation. At the time of incorporation, every company has to register its MOA, but it is not mandatory for the company to register AOA. The next one, the major contents. It contains 5 clauses: name, registered, office, object, liability, and capital clause. So they are saying that one, name clause, registered clause, object clause, liability clause, and capital clause. These are the major 5 contents what we have in MOA. But in the AOA, it differs from company to another. However, table F can also be adopted. Means AOA depends on the line of the business or the structure of the business. So AOA cannot be same for all the organization, but MOA will be same for all the organizations. Next one, mandatory drafting means compulsory. It is compulsory to draft MOA. It is compulsory for all the organizations to draft the MOA. A private company has to formulate the AOA, while public company can adopt table F of the Companies Act 2013. If it is a private company, it has to formulate AOA. If it is a public company, it can have table F. The next 6th difference, alteration. Alteration means any modification if it is required in future. What is the procedure? So it can alter any 5 clauses of the memorandum as different conditions in addition to a special resolution. Means they are saying that if I want to modify the memorandum of association clauses, we have to pass a special resolution, then only it will be accepted. Articles can be altered with a special resolution. Even articles can be modified by passing a special resolution in the board meeting. The next one, relation. It manages relations of the company with outsiders. The total MOA is based on the relation with the outside the world of the company. Now, these instructions are internal management of the company. AO is related to the internal part of the company. MO is related for the outside of the company's activities. Now, the breach, the law what we have, anything done in contrast to the memorandum is void and the doctrine of ultra vires is applicable. They're saying that if we are going to do the activities which are not mentioned in our MOA, then it is going to be void, means cancelled. So next, it is a binding force only in respect to the matters between the members inter se and between the members and the company. Whatever the AOA has been framed, it is only for the internal purpose. It can be made that when if anything happens there, it is only related to the members who are internally dealt in the organization. Next, we have here, as we were discussing about alteration, the first part of alteration of MOA, we are going to discuss here. Alteration of MOA, the following procedures have laid down by the Companies Act 2013 in order to alter MOA of the company. The provisions of the memorandum, for the purpose of alteration may be divided into two. They are saying that when the provisions will be classified into two parts at the time of alteration. The first provision, it must included in the memorandum of the name, object, place of registered office, etc. They are saying that when they have to include the name of the company, the official address of the company, and the registered place, and what is the object of the company, and even exact registered office. The other one will be appointment of manager, managing director. In the other provision, they're saying that when the second provision, whatever we have here, they're saying that when appointment of manager as well as the managing director for the organization. In this one, the first clause, the name clause, if I want to change the name of the company, so then for changing of the name, section 21 lays down that a company may change its name by special provisions provided by the company law board approves of the change, but no such approval is necessary in case of addition or deletion of the word private when a public company is converted into a private company. They're saying that when if I want to modify my name, so then we have to pass a special resolution. Means if I'm going to change my name company, for example, if it is a Sun Motors Private Limited and I'm changing to Sunshine Motors Limited Private Limited, then we have to have the change of name, section 21. Now, if it is a public company, if I want to add private limited, we are converting our public company into a private company, so then such clause is not required. A changing clause is not required. In the reverse manner, if the private limited is going to be changed for a public company, again, it is not required here to change the limited or private limited. Only in case of change of name, we have to do. The next one, change of object. If I want to change the object of the company, then under section 17 to 19, so there are certain rules and regulations are framed here. For what purpose the objective of the company is going to be modified, whether there will be any small changes are required to the organization to survive in the world, means they are going to have the increasing their qualities or increasing the services motto. So then it can change through the objects of the company here. So next one we have here, see here in that one, to carry on its business more economically and more efficiently. If the business wants to conduct it through economical and efficient, they can have that one. Or to obtain its main purpose by new and improved means to adopt the new technology, to increase our services, to provide quality services or efficient of the workers. At that time, it can change through the object clause 17 and 19. Next, to enlarge, change the local area of its operation. Earlier, my object was only to work in the district of Mysuru. Now, I want to work in the entire Karnataka state. So then, I have to have the change of object clause. Next one, to carry on some business which under existing circumstances may conveniently, advantageously be combined with the object specified in the MOA. They're saying that one, if they want to change the concept here from one concept to the other and to add some more products or the provisions, then they have to adopt this change of object clause. Next one, change in registered office. If the company wants to change the registered place from one place to other place, like it may be from village to city, or like in the city itself from Mysuru city to any other city. So then they have to adopt change of registered office. Like the first part here, the change of registered office from one place to another place in the same city, town or village. So this changes has to be made through the provisions. Change of registered office from one town to another town of the same state, means in the same Karnataka, if I'm going to change, then I have to pass a special resolution, has to be passed for the approval. Change of registered office from one state to another state. I'm changing from Karnataka to Andhra, Andhra to Karnataka, or Tamil Nadu, or any other north states here. So then we have to have the change of registered office concept has to be adopted, and the provisions has to be considered, and a special resolution has to be passed in the meeting. Next, we have here alteration of capital. The next changes, if it is required for the company, for the capital, as earlier I said that one, if we are starting with the 50 lakhs of the business here, whether if I want to increase my capital and modify to 100 crores, then I have to have the provisions for alteration in such a way that when this alteration of capital clause is adopted for increasing my capital, or to reduce my capital, or variation of shareholders' right. If I want to modify the rights of the shareholders, we can adopt the alteration of capital clause. Next, we have here alteration of association. That is nothing but alteration for the modification for AOA. The first one, procedure for alteration. A special resolution must be passed under Section 17, subclause 1 of Companies Act 2013, says that when the alteration must be confirmed by the Company Law Board on petition. Section 17, subclause 2. Notice must be given to every person whose interest will be affected by the alteration. Means a notice means a communication has to be sent for all the people who are interest of the business here. For them, if any names or any changes are made here, so then if there is any possibility of changes in their interest to continue or not. And the consent of the creditors of the company must be obtained, and claims has to be made discharged, secured. Section 17, subclause 3. So here they saying that even we have to take the permission of the creditors, and even in case sometimes if any contract has to be discharged, we have to get the permission of those people, then only we can make the alteration, or else we can't do any alteration of our AOA. The second one, notice must be given to the registrar of companies after making certain alteration of the AOA. The main copy of the alteration has to be given to the ROC as well as, so that appear before the Company Law Board and state its objections and suggestions, if any, in regard to the confirmation. They're saying that why the alteration has to be required and what was the purpose it was made, and everything has to be conveyed to the ROC. The Company Law Board may make an order confirming the alteration either wholly or in part in such terms of conditions as things fit. They're saying that it has to present themselves in the Company Law Board for the alteration of association, modification, and then it has to present themselves and convey the message to them for the alteration permission. the company law board may accept the total modifications, or it may say a part of the points has been accepted here and the remaining are not accepted here. Alteration of articles procedure, whatever we have here according to the sections 40 and 192 1 and 2 of the Companies Act, a company may alter the rules and regulations that are contained in its article anytime by passing a special resolution. They're saying that by passing a small resolution, we can modify the articles of association. Although a copy of the special resolution altering AOA must be filled with the registrar within 30 days. They're saying that after modifying the AOA, a copy of the same has to be submitted to the ROC within 30 days. Section 31 subclause 2 also states that any alteration made in the articles shall be as valid as if original contained in the AOA and shall be subject in like manner to alteration by a special resolution. They're saying that the entire concept under section 31 subclause 2 states that alteration made for the AOA and the copy whatever we have, it stands equal to the original copy what we have made earlier, and now it has to be get approved from the company law board. Thank you to all my dear students. In the present session, we learned about the key differences between MOA and AOA. In the same manner, we learned about the alterations of MOA as well as AOA, under which section are the provisions are made and what were the provisions. Thank you.